Hey everyone, Harry here to talk about the appeal in Donald Trump's liability verdict in his first defamation trial brought by Carroll, which might have missed in the flurry of news late last week. Okay, so recall this one. She sues him for defamation. He basically doesn't even show up for trial and is high-handed about it and loses a $5 million verdict. And conveniently for her, because the first defamation occurred while he was president and was tangled up in issues of, immunity, or is he acting under color of law, or which goes to whether or not the DOJ would substitute for him and the case would have gone away. Remember all that stuff? He very conveniently for her made it go away by defaming her again after his presidency, so then permitting her to bring another case, which resulted in an $83.3 million verdict. This is the first one, though the cases have sort of lapped and overlapped each other while working out the various complications or legal arguments he launched based on his having been president at the time. Okay, so this first one from $5 million goes up to the Second Circuit, which the Court of Appeals below the Supreme Court. Robbie Kaplan, who represented Eugene Carroll at trial, handles the appeal for her. And John Sawyer, now Trump's favored member in the appellate bullpen, who argued the immunity case, handles it for Trump. And the headline is, I don't see anything there that is going to interest the Second Circuit, and I think they are likely to affirm without, much trouble. And indeed, so what Sawyer was basically trotting out were a series of evidentiary rulings that not the sort of stuff that you see courts of appeals reverse convictions for, and B, are always subject to so-called harmless error reviews. In other words, even if the Court of Appeals finds that piece or this piece of evidence shouldn't have been admitted, so that you don't, with every little mistake that can, which are unavoidable in a long trial, have to go all the way back to the beginning after all the resources and focus the system has put in it. Harmless error is a doctrine that says if it probably wouldn't have made a difference, the evidence was such that it wouldn't have made a difference, we're not going to reverse a conviction. And you can imagine that when they're overlooking evidentiary questions, they themselves, courts of appeals judges, are not so familiar with trial setting. They want to defer to a court. There's a pretty strong temptation to say, well, if there was any error, it was harmless, or even, there was error, but it was harmless. And the questions that were in front of the court all seem to be of that garden variety nature. The focus was on two rulings by District Judge Kaplan in particular that will be the main argument Trump makes on appeal. I think that it was the main argument he made, and when we see the opinion, it'll probably lead with this. And that there's the admission. So recall, he is accused of sexually assaulting Eugene Carroll in a Bloomingdale's dressing room, but quite some time ago, and the court permitted Carroll to introduce evidence of other sexual assaults or other alleged sexual assaults. It's not as if, they've been proven beyond a reasonable doubt, but there were two. There was an episode of groping on an airplane and an episode at an interview where he sort of threw himself at a reporter. The jury heard that evidence, and that can be pretty influential evidence. You're a jury. You hear about other times he's done stuff like that. The temptation is strong to human nature to say, I'm not exactly sure what happened this time, but we don't have to really worry about it. Look what he did before. If he did it before, it's pretty likely he did it again. That inference, did it before, likely did it again, is one that the law forbids. The defendant has to be tried for his actual, deed that they're being alleged to have done. But there are special rules where the past bad conduct involves sexual misconduct and sexual assault. There's a rule of federal evidence, Rule 415, that the evidence that a defendant committed any other sexual assault basically may be admitted in other kinds of bad crimes or bad deeds, bank robbery or whatever. You need to state sort of a special theory about why it's not going to that forbidden propensity inference. Did it before, did it again. It doesn't say that for sexual assault, so it's just subject to a whether it's relevant and whether it would be super prejudicial to the defendant. So on that basis, it was admitted here, and on that basis, I see it very unlikely that the Court of Appeals will do anything to reverse. So I think this is going to stand up, and now coming, like a freight train, next is the $83.3 million verdict. And just for good measure, this, fill in the blank, A, creep, B, asshole, C, moron, D, all of the above, once again defames Eugene Carroll and he leaves Trump was in the courtroom. That's a kind of a noteworthy fact that I should have mentioned a little earlier, but he chose to go. He was feet away from Eugene Carroll as he did, but it was a short argument, 20, 30 minutes, and he left and went right away, but then held a press conference up at Trump Tower. Once again, just said, I never did this. It's a complete lie, made it up, exactly the opposite of what was found below. And then just for good measure, he said 2 or 3 times in kind of bizarre and incredibly narcissistic language that Eugene Carroll, if he was doing this, wouldn't have been the chosen one. She wouldn't have been the chosen one. But it's another, a way of saying basically, as he did before in his crass Trumpian way, I don't find her attractive anyway, so I wouldn't. That's the great defense to sexual assault. So I wouldn't have assaulted her if I were choosing whom to assault. So, maybe stay tuned for yet another. And we went from 5 million in the first to 83.3 million. And, this is a little bit, it's got the 2 elements of the other 2 defamations. First, basically, as I just said, she's unattractive or something, or it was in 91. And then second, it never happened, which is to say she's lying. She's making it up. So, this might be a lifetime pursuit. If Eugene Carroll is now 80 and has been, completely, subjected to all kinds of insults and public pressure, not just from Trump, but MAGA Nation, wants to pursue. So I wouldn't be surprised if they don't bring another suit. On the other hand, we shouldn't be surprised that, a leopard doesn't change his spots or whatever. And even after appeal, when any defendant would know to shut up, Trump comes and, and absolutely demeans her again and just says stuff that, like so much he does, violate the basic rules of everything I need to know I learned in kindergarten. Okay, Second Circuit appeal, probably a few months till you see it, though. Sometimes they do things very quick if it's considered super easy. So that could happen, but I think in this case, more likely it'll be a period of months, but I would look for an affirm. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.